Hey, hello. We're going to contract again. Welcome to part 2. In part 1, we covered the formation and now we're going to cover the content and the termination. This will be a shorter lecture, so stay put. Step 2. How did we get there? Well, we checked at the formation whether or not there was an offer and an acceptance. We checked whether or not parties had legal capacity, and then we checked if there was a defective will or not. In case we had an offer and acceptance, parties with legal capacity, that means they were not a minor and not under guardianship, and our parties also declared something they wanted, we have a binding contract. And that gives us permission to go to step 2. And we're going to see what is in the content of the contract. Well, you know what is there. There are obligations there. Because the agreement on one hand leads to obligations for parties that they have to perform. That's the whole idea of the contract. So in step 2, we check the contract. We see who has an obligation to do what exactly. For your business, this is a really important step because here is where you can take the lead, where you exclude your liability, lower your liability, and where we, your legal department, will protect you from any liability claims possible. So for you, the content of the contract is really important. As I already indicated, we formed that contract. We had an offer, an acceptance. Parties with legal capacity, the will and declaration matched. So what do we have? An obligation. What is an obligation for your business? An obligation indicates a liability. It's like two sides of the same coin. On one hand, you have an obligation to pay something, to deliver something. On the other hand, because you have a binding contract, you're immediately liable for it. So you have to perform to fulfill your obligation. If you do not do that, you are liable. And that is a really very strict rule in contracting, because that is like the whole idea, the ground under the contracting. It is all written down in Article 674, so that is Book 6 about contracts and obligations, Article 74. And this article, people, this is the giant in contract law, because this is like fighting with a winner. This is a huge article. It says if you have an obligation, you have to perform. It says if you do not perform, you're liable for the consequences, and you have to either perform or you have to cover damages, all the damages, not only the damage that you immediately cause or directly cause, but all the damages that derive from you lacking to perform. Your failure to perform makes you liable for damages. And that is a very strict thing. And for me, like as being like a lawyer in a company, that's a very frightening thought, because we want to lower your liability to maximize your profit. That is really what your legal department aims for, together with your financial department, I must say. Well, if you want to try to see the difference between the daily language and what you could find in it when you would work in a legal profession, you can do this very small exercise. So we have a situation where somebody works in a restaurant. He wants to go to the supermarket to get something for his lunch, and then the boss says, "Oh, I forgot to buy me some apples. Can you bring some?" "Okay, of course," says the employee. And that is a very normal daily situation. In a contract, that would be like a deathly trap. So many things could go wrong. So you can pause now and think about all the things that can go wrong. And then on this slide, you can see how many of these you already thought about. Because actually nothing was clear in the assignment. And that leaves all open questions, and you do not know what is going to happen. What will be the answer to all those open questions? Imagine if you have a company and you do business with another company, if you would have a contract that has open questions, open endings everywhere, that could mean so much liability and so much cost for you as a company. And that's why we don't want that. And that's why we want a really solid content for you. So that's as far as the content goes. For a company, very important to write a content that is good for your company and it protects your company. On the other hand, for us, when we judge a case, the content, the story that people tell us and the story that you will get on your test will give you a possibility to determine what the obligations were that parties had to perform. Why am I so keen on discovering these obligations? It's because that is what parties have to perform, both 100%. 100% performance, nothing less. And that is the key to your liability. If you perform less, you're liable. So we have to exactly know what parties have to do. If they do not perform, they are liable for it. That leads us to this step 3, the termination, because every contract comes to an end. And then on the left, you see the happy cake. And really, most of the time, it ends very happily, of course. People do what they have to do. They do what they agreed on. Everybody's good. And the contract automatically ends all by itself. You don't have to do anything for it. But at your test and in my office, it is different. There we find the people that were in a contract where not everybody performed 100%. So maybe they lost money or they ordered something and never received anything. So somebody then is liable because, as you can see with the cake has a gap. That gap is the difference between 100% performance or less. And we can end the contract only if we have the entire cake. So somebody has to put that piece back or give the money to buy an entirely nice 100% new cake. And that is a little bit contract law and the termination and the questions about liability in a nutshell. So we check in the termination at the end when we find we have a contract. Did parties actually perform 100% or did somebody fail? And if that person fails, we will figure out, are you liable for your failure or is there a small chance that you're not? And the chances that you're not liable, as you can see in this picture, they are really very small. 674, I said it to you, this is the fighter, this is the winner, this is like the giant in contract law. If I have 674 on my side, I feel very lucky because 674 says to the other party, listen, you didn't perform well, you have to compensate all my damages. And then the other party, what can they do? They can say, but I had a perfect legal excuse for my non-performance, and we call that a force majeure, An article that belongs with that is again in book 6 and it's article 75. And you see already that the little puppet there, the little child, it's very small. So if you have the big guy 674 against the tiny little 675, you don't stand a chance when you're 675 because a force majeure is almost never taking place. It is really, people call it something, an act of God, something out of their hands. It's a tsunami or a war that goes on suddenly, a tornado that lifted you up and never put you down. Really, in very, very rare cases, we speak of a force majeure that has as a consequence that you are not liable for the damages, that it cannot be attributed to you. But again, almost never. If you are sick, if you fall, if you break your legs and cannot perform, that is all a risk that belongs with you. So if you enter into a contract, you have a really large amount of events come as a risk for you. You have to perform, and there can be many cases where it's not really your fault that you can't perform, but it's still your risk, and then you are liable. Therefore, We will see in another chapter of these video lectures that you can do something against that with general terms, and I will tell you about that later. But for now, when there is a breach of contract, so there is a gap in the performances, somebody did not perform 100%, basically that person is liable for the damages unless there was a rare case of force majeure. That is how the law puts it. Very black and white, a very big chance that you're liable. This is already the end of part 2. We covered the content of the contract. In the content, you protect your company from liability, and we determine the obligations that parties have to perform, because that's very important to us, because then we can see whether or not we can end this contract. The termination. The termination has can only be done actually if both parties performed 100%. Or one party performed 100%, but the other covered his lack of performance with paying damages. So something has to be in balance. We have to find a balance. If one or both parties perform less than 100%, we have a gap that we call a breach of contract. And usually the person that causes that gap has the risk of being liable for the damages that he causes. Unless in very, very rare cases, very tiny, very rare, little puppet 675, a force majeure happens. But that's almost never. So basically, you contract. You take upon yourself an obligation you have to perform. If you don't, you're liable for the damages. That is contracting, and that is the way the law has put it. That's all for now. I will continue with another lecture on explaining the IRAC for you, because it directly relates to all this contract law. Thank you for watching.